All right, 15 participants. Thank you, Jackie. I am so glad to be a part of this team where we all help each other out and we're not shy, including us leaders, to point out that we don't always have all the answers immediately. So, but thank you, all of you, for joining us. And today's live meeting is about RESPs and estate issues. And this all came out of the training, actually, where we were getting prepared for online advice. And it became obvious to all of us that when clients go into the online advice experience and create an RESP account or request an opening, it only allows to open in single name, so an individual subscriber account. And some questions did come out with regards to, well, how does that impact estates? And at the time, I don't think we had proper information and we weren't entirely sure. So I endeavored to take that away and had a chat with Linda Lamarche, and she's got some answers for us. And from there, we've got some new processes to ensure that we do take care of our customers and that we're protecting their beneficiaries and their RESPs. So this brings me to welcoming Linda. Linda Lamarche is a CFP, and she is a Senior Solutions Analyst for ATB Investor Services, with her focus being on the financial planning side of things. So anytime, and I know many of you have probably accessed her before, although there are a couple of newer members on the team, although I know that Viva and Brittany, you were here before, but perhaps you've not had an opportunity to meet Linda in that time. So she's the person we all turn to when we don't know how the financial planning world or CRA or, all those elements view certain situations. So thank you, Linda, for joining us. She has a great story to share, and I think what I'll do is I'll just turn over to Linda, and she's got her presentation for us. And then after her presentation, there will absolutely be time for a Q&A session for her. And then we will also take a look at, what do we do in the case where a client wants to have a joint subscriber account. So, and again, closing with a Q&A on that. So I'll just turn it over to Linda.
Okay, thank you very much, Michelle. Yeah, I recognize quite a few of those names, and then there's quite a few that look brand new to me. So, yeah, I'm looking forward to getting to know those of you that I don't know yet. So, as Michelle indicated, we're going to talk about some of the issues that happen with RESP accounts. And, oh, there we go. My slides are going. So, with an RESP, obviously they have beneficiaries that are the children of the RESP. But unlike what we're familiar with in regards to beneficiaries, RESP beneficiaries kind of are classified differently. So generally there's assets that become part of your estate when you die, and there's assets that bypass the estate. So if you own a house jointly with somebody, or a joint investment account, and you pass away, that asset never goes through your estate. It just slides right over to the joint account holder. So there could be tax issues, but as far as ownership goes, those things don't go through your estate. Same thing when you name a beneficiary in an RSP account, that RSP just gets paid right out to that beneficiary, and it doesn't go into your estate. Same thing with life insurance. So even though we use the term beneficiary with RESPs, it's not quite the same. And when you pass away, when there's not a joint subscriber, and you're the subscriber of the RESP, that asset when you pass away belongs to your estate and would theoretically go to beneficiaries of your estate, not necessarily the beneficiary of RESP, if you had like nieces and nephews and things like that. I'll go through some examples a little later on because I know it's a little confusing. So when assets go into your estate, they're subject to creditors and claims and probate fees. And then once all your estate's cleared up, you can distribute them according to the will, or if there is no will, according to the Wills and Succession Act. So if there's no joint subscriber for that RESP to flow over, then the beneficiary of the estate is entitled not the beneficiary of the RESP, and sometimes they're the same, and sometimes the person that's the beneficiary of your estate would have been the person that you would have wanted to be your joint subscriber, so it's not an issue. So, oh, sorry, I'm not technology literate. So why does it matter? But there's different outcomes that can happen. So if there's a joint subscriber and one of the subscriber passes away, like we discussed, the RSP continues and passes to the surviving joint subscriber. Generally speaking, if you are a husband and a wife and you have 2 kids, the most efficient thing to do would be to have the other spouse as the joint subscriber. If the other spouse isn't a joint subscriber, but would still be entitled to your assets, it takes a few more steps to get them to that point. So if you're an individual subscriber and you pass away, or if there's joint subscribers and you both pass away in a common accident, then the RSP is, like we said, it's going to go into the estate, subject to creditors, claims, probate fees. Other assets can be used to pay those things, but depending what other assets that someone has available, it may be that the RESP has to be collapsed to deal with that. So when it goes to the estate, it's either going to continue and there's been a replacement or subscriber that takes over the person who's entitled to your assets. Like we said, if it's the husband and he's the one that's going to be the beneficiary of your estate, he can become a successor subscriber. It can be collapsed and distributed to the RESP beneficiaries. If they're no, when it falls to the estate, I think that would be if it's mentioned in the will, and we'll go through the different examples. And then it can also be collapsed. So part of the problem is that when an RSP is collapsed prior to the time when the beneficiaries are attending school, the grants have to go back to the government, and the income and earnings is not available. So there's certain conditions that have to be met to be able to get the income and earnings out of the RESP. And if you're choosing to collapse it before those conditions are met, then you have to forfeit that income and earnings. And when you fill out your RESP applications, you're often electing what financial institution you would want to get that. So when you've had to collapse your RESP to go into your estate to pay bills or to do things, often all that's left is the contribution. So that's generally not the ideal situation. So regardless of whether it's a joint or individual subscriber, it's important to provide provisions in your will with regards to what should happen with the RESP on your death or on the death of subscribers. Because basically your executor has to follow what your will says. So if there's nothing in your will saying the RESP that I have for my nieces and nephews should continue for my nieces and nephews, your executor doesn't necessarily have the ability to say that or do that. Oh, I've done it again. Sorry. Yeah, you can add a codicil. So instead of rewriting your entire will, I would say you'd want to get it done with a lawyer. It's complicated, and yes, you could add a letter to your will, but getting legal advice is the more appropriate response that we should be giving our clients. I'll walk through this example that if we have a married couple and the wife is the subscriber. Oh, thank you, Michelle. Married couple, wife is subscriber of an RSP for their 2 children. So this might be one of the cases that you guys run into if people are just saying that, yeah, no, I don't want to add my husband as a joint subscriber. I just want to take care of it. It's simple. I can't deal with this right now. And she passes away. Well, if he was the joint subscriber, the RSP would continue in his name. He'd feel free to maintain or collapse for his benefit or the benefit of the RESP beneficiaries. And because he's a joint subscriber, he has all the same options available to him. They both are jointly in charge of that RESP. So again, if for some reason he needed to collapse the plan before the kids went to school, it's subject to the grant and the accumulated income payment rules. Theoretically, it's pretty much the same result, but you got to jump through more hoops if she had no will, or and the husband was named as the only beneficiary in the will. That the RSP would fall into her estate, subject to probate fees, may have to be access to pay creditors. Generally speaking, or CRA, she's not going to have that much tax because she has a spouse, so most of the assets are going to roll over on a tax-deferred basis when she passes away. And then if the RSP still exists, he's entitled to her estate assets, so he can become a successor subscriber of that RESP. And again, do with as he sees fit, but generally he's got his kids he'd like to take care of their education. So, but the most effective and efficient option would be to have him as a joint subscriber. You're avoiding probate fees, and it's a simple process, and it's you don't have to go to the court, get the will probated. It's just, well, actually, I think we still do, but it's a much simpler process. So let's take a married couple with no children. The wife is a subscriber of her RSP for her sister's kids. She passes away. Maybe you don't want your husband as a joint subscriber because now he's the joint subscriber of this RSP for your sister's kids that he may have never liked the sister to begin with, or doesn't really have much use for her snotty little children. So he basically has access to this RESP, and again, he can do it as he sees fit. He may love his nieces and nephews and want to keep contributing to the RESP, want to manage it and honor your wishes. So if that may be what your option you want, maybe you did want him to be the joint subscriber. Maybe your sister's a spendthrift and you don't want her to have access. But if he's a joint subscriber, that's what's going to happen. If there's no will, where the husband is named the only beneficiary in the will, again, he would inherit the rights to that RESP. It's going to go through the estate process. Eventually, he becomes the owner of the rights to that RESP, and he can do it as he wishes. But obviously, he can't just say, oh, I think your sister can be the subscriber, because that was never in your will and that was never your intent. So if you want your sister to be named as a subscriber without direction of the will, that's not an option. So if that's what you want, put it in your will. Because, yeah, you don't know that what you want is going to happen if it's not in your will. So we'll say another one, a single mother with 2 children, subscribed, and she's a subscriber of the RSP and she passes away. So with no will, since she doesn't have a spouse, there's no ability to name a joint subscriber. As she doesn't have a will, her children would be her estate beneficiary. So according to the Alberta Wills and Succession Act, if you don't have a spouse and your only heirs are your children, then they would be the beneficiaries, but the assets have to be held in trust for them until they're 18. So the RESP falls into her estate, subject to probate fees, and they have to be access to pay creditors. If the RESP is still in existence after that, then the executor, the estate, can become the successor and hold the RESP until the children are 18 and use it for their educational purposes, or at 18, so basically, because there was no will, the children are entitled to deal with their inheritance once they become 18. So if she had a will, same thing's going to happen. The grants stay inside and will and last as long as the RESP. So as long as the RESP is existent, grants will stay in there. If they've had to pull money out for some reason, grants go back or clawed back on a proportionary basis based on how. So to make sure people aren't just putting money in and then taking their own money out and leaving the grants in, there's a little clawback mechanism in there. So as long as the money is still in there, the kids are going to school, they'll be able to access the grants and the income if they're using an educational payment. But once they turn 18, if they're not going to school and they want their share, then the grants would go back to the government because they're not being used for educational purposes. They don't meet the qualifications for an EAP. And the income in plan can either stay there till it meets the requirements for the income. So I think the plan has to be 35 years old, or anyone that the beneficiaries have to be at least 21 years old. So they could potentially take out their contributions but leave the income in there until they're 21 and then take out the income. But basically it's the same rules that apply to anyone with the RESP. If they're using it for education, they get grants and income. If they're just taking it out, grants go back, and they can wait to get the income. In the case of if she has a will, she has a lot more ability to control what happens. She can elect another individual to be the successor subscriber. It doesn't necessarily have to be the executor of the estate. She can provide additional direction with regards to the children's ability to access, that if they're not using it to actually pay for the education, that it's being entrusted until they're a certain age, etc. So there's a lot more. She has the ability to put a lot more control over what happens if she makes sure she takes care of it in her will. So this one is a little more complicated, and it's not just with regards to RESP estate planning. We've got a situation where a widowed grandmother has 2 adult children. She has a $100,000 RSP, and she's named her son as a direct beneficiary of that RSP in the contract. She's been a subscriber for an RSP for her daughter's teen children, and it's worth $60,000. So in her mind, she thought, I've put money away from my son, he'll get my RSP when I pass away, I'm contributing to my daughter's family, they'll get the RSP, and she passes away and she has no will. So because the son was named direct beneficiary of the RSP, he's going to receive a check for $100,000 from a financial institution. Since the RSP is included in her income, and the deceased grandmother is theoretically the one that has to pay the tax, and it will come out of her estate. The $100,000 is combined with the other income she's earned in a year, and let's say the estate has to pay $30,000 in taxes. The RSP has become part of the estate. She's passed away with no will. So again, according to the Alberta Wills and Succession Act, her son and daughter are to share the residue of the estate equally. So as a result, the executor is going to liquidate the estate assets to pay her tax bill. So in the RESP, she has $60,000, but the reality is the executor doesn't have access to the whole 60. They can only get $45,000 of contributions out. So the $45,000 is going to go into the estate. $30,000 of that is going to pay taxes. That leaves $15,000. And according to the succession laws, that $15,000 has to be split between the son and daughter equally. So because that RSP is one of those assets, and because it had a named beneficiary and it went outside of the estate, it's not included in the estate asset. So the son ends up getting $107,500. The daughter gets $7,500. There's nothing for the grandkids. Obviously, that wasn't the grandmother's intent. So she should have named, first of all, the estate as the beneficiary of the RSP. Her will should have indicated that the daughter is to become the successor subscriber of the RSP, and that the residue of the estate is split between the daughter and son. So whether it's 50-50 or she wants the son to get more because the daughter's children are getting the RSP, that's up to her. But there's a significant difference if your estate issues are not handled appropriately. And I almost did it again. Are there any questions? Because I think I went through that rather fast.
I just have a question. So for a joint subscribers account,
Yep.
if something happens to, both mom and dad at the same time, do they have to talk about these RESP accounts individually in their wills?
Yes, or else the Alberta Wills and Succession Act will decide what happens. So if when a couple dies at the same time, rights of each individual as survivor would be considered, and joint property with right of survivors would be deemed to be held as tenants in common. So theoretically, they're each entitled to have their selective inheritors would be entitled to half of the RESP. Now, realistically, if it's their own kids, it's not a big deal because, as we've just heard, if you die and your only inheritance are children, the children are entitled to those assets and they have to be held in trust till the children are 18. So again, it would be the situation like a single mom. But if they were joint subscribers of an RESP for someone else's children, and they passed away and one of them had a father surviving and one of them had a mother, then their parents would theoretically be entitled to the estate assets. Now, so that's kind of the situation similar to, do you really want your husband as joint subscriber on your niece and nephew's account? Probably not, because you'd rather have your sister or leave direction in your will. But yeah, if they die together, there still should be direction in the will because otherwise it's like the single mom die.
Wow, these are great examples, Linda. I think of my brother who is a subscriber for an RESP for his godchildren. So, and they're friends of, the children of his friends, right? So there are a number of scenarios out there. We can't always think that it's, parents holding accounts for their children. There's always other options or other scenarios out there.
Yeah, so he could pass away and his wife's entitled to everything and maybe she doesn't have a connection with his family. And it might very well be that he'd want his wife to have access if they're, realistically, I don't think, people who are starting RESPs for other people's children are probably well off. So their own spouses may not need those assets, but.
Yeah. So Lucinda has a question. Linda, can you see that?
If both kids are now 18 and the RSP is still being in school and both parents die, what happens? Again, it depends on what the will says. If they're both 18, they're entitled, if they were the ones that, if there's no will, they're the ones that are entitled to the RESP subscribers' rights. So they can choose to continue the RESP as the subscriber and take the grants and do what they want, like access it for educational assistance payments and use the income and use the grants. But if they're not qualified to go to school and they're collapsing the RSP, then the grants go back. So,
Linda, okay, so it's Lucinda. Hi. So yes, let's say there is a will, but let's just say they didn't put a special letter with, and so both subscribers have passed away now, and these two are the beneficiaries. So, but they're both over 18. So what? It just reverts to whatever the will says for the estate.
Yeah. So they'd inherit the rights as a subscriber.
Okay, as a subscriber. Okay.
So then once they inherit the rights as a subscriber, they have all the powers and all the abilities that the subscriber had. So they can make an RESP withdrawal. They can just withdraw contributions. They can collapse it. I don't know how it would work exactly when there's two beneficiaries. If the RESP gets divided up into two individual plans, if that's how it's handled, or
do they get their parts, if you know what I mean? Because, two kids are 2 years apart, and one's it's still got grant money in there, and one's depleted it, and now they're into the regular stuff, right?
Yeah, no, I honestly don't know how that's handled.
And it's interesting, Linda, because you say that they could potentially become the subscriber on their own RESP. Like it would be their name as subscriber rather than the executor's name as subscriber, for example.
That seems to be what I'm reading now. Whether that's the process that we would take, that is, yeah, I'm not sure what our process is exactly for that particular situation, but it could very well be that the executor's name, once it's on there, stays on there, but because the executor is theoretically holding that RESP in trust for them, that the executor is the one, or the trustee, if it's been named as a trustee, is the one making the decisions until they're 18. And then I'm sure once they are 18, they can tell the executor, I want my money now, or this is what I want. And the executor, if there was no instruction in the will to keep it till they were 25, once they're 18, the executor would have to take their direction, or they could take it to court.
Yeah. And at the same time, Lucinda, the executor may decide not to maintain it. I can share an example where I, as an advisor, had a client with a significant RESP. It was a grandmother with 19 grandchildren beneficiaries on the plan. And the executors, I can't remember now what her instructions were in the will, but the executors did not want to maintain that RESP because there were some newborn children in that plan and there were some 20-year-old children in that plan. And so the executors were like, we don't want a job for the next 25 years. So they had the liberal rights and they chose to withdraw all of the contributions from the plan. They paid those contributions out to the beneficiaries according to the will, and they maintained the income and grants within the plan, and their plan was they kind of had this schedule where they thought, okay, maybe over 6 years we'll be able to pay out grant and income to the older children as they make educational age assistance payment requests. So the executors can have a lot of discretion if the will's not very clear, as Linda's saying. So, I mean, in the end, it's just important to understand what the possibilities are and to remember that you're not legal advisors, right, Linda? So, it's just to create awareness with the clients and to have them inquire with their lawyers as to what their lawyers would suggest for them to do. But at least to bring the awareness to them that some of their choices may impact outcomes or create outcomes that's not really their intention. So any other questions for Linda? Lots of time.
I actually have a question, but it would be more of a processing question than around the legal implications. So.
Yeah. And we'll move into processing. We'll just give a little bit of time for questions around the estate matters, and then we'll discuss a little bit about processing, and then we can see we might answer your question there.
Okay, thanks.
Any other questions for Linda with regards to estate planning and RESPs? And certainly, if you have a question, don't be afraid to unmute. I see Lucinda is typing. Aha, yes, thank you, Lucinda. Linda, you do have a follow-up email for them after this, don't you?
Yeah. So I'll send you the slides, as well as I'll send you just a couple links to some information with regards to, legal things confirming what we talked about, and the things that how your assets are distributed if you die without a will, and just various documents.
Right.
The documents, I'm not sure what our rules are with regards to sending links to just articles online. I'm not sure what your rules are. So the ones I know you can send to clients, I'll say these ones can be shared with clients, and then the ones that are just linked to like a blog or article, I'm not sure if you're allowed to or not. So
Okay, and good question, Linda. I'm not sure either. So maybe that's something we can look into, and we could, I mean, if some of this information is valuable, Lucinda, it might make sense. You're part of the client experience committee. Might make sense that that's a client experience committee takeaway to say, oh, is that maybe links we want to include in the online tool itself, right? So that we're not necessarily emailing, but we're directing the client to articles already available on the tool. Yeah. All right. Well, what I'm going to do is I'm going to try something I've never done before. I'm going to launch a poll. So I was kind of playing in this, and I discovered a poll, and I hope this works. So please, I've just launched. I'm hoping everyone can see on their screen. Maybe someone can confirm if you can. Wonderful. Thank you, Lucinda and Jackie. So if you could take a few moments to share with us if you're confident further to Linda's presentation that you can explain to client the impacts of death of a subscriber of an RESP and how, give them some thoughts on how to protect their RESP beneficiaries. Oh, so far it's looking good. We have 14 respondents. I think it says we have 18 participants, but I think between the leaders, we've probably got all of our advisors who've already responded. So I'm going to close the poll.
That's an awesome tool.
Yeah, I've seen Rita use it, and I've seen, I think it's the engagement committee or one of the committees. Maybe it was Mastery. So I thought, oh, I'm going to play with this. Aha, Mastery. Yes, thanks, Jackie. So now, let me know if you can see the results, everyone. I think I've clicked on a button saying results are shown. And so we can see, Linda, awesome job. We've got 93% feeling confident and 7% somewhat confident. And so I'm thinking perhaps they'll move more towards the very confident stage once they have the ability to let it sink in and to take a look at some of the materials you send them, and then maybe follow up with more questions as well.
Yeah, I'm definitely available for any questions.
All right. So Linda has just said you can send her questions if you have any further to this. All right. So while we still have Linda, any last questions for her before we move on to more of the, how do we support clients then in opening a joint account if that's what they want? Okay, looks like we're good to go. Linda, did you want to stick around for a little bit more in case more questions come out? Because awesome, thank you.
Yeah.
I'm going to share my desktop. A QRC that was created, and I want to make sure that everyone, and now I want to make sure I'm hearing, there we go. I want to make sure that everyone is aware of a QRC that's available, and so I'm in the intranet, and if you go into the investor services area, under the online advice project, and I'm sure many and all, likely all of you have gone to this site already, in the launch and beyond page. I'm just I heard some beeping. Can't see now. Okay, so good. Lucinda can see. If anyone can't see my screen, do let me know. And this is our launch and beyond page where we've got a number of tools available for you. And so under the queues and team management area, there is under the fulfillment queue a QRC with regards to our ESPs. Someone's sending a note. Ah, Shane, wonderful. He's put it in as a favorite in his browser. Absolutely, so have I, actually. You can see it. It's right here. I've got my quick launch bar, but I did want to show everyone how to access it. And this is your RESP quick reference card. And this is more around what do you do when you get a new account request for an RESP? And so a new account workflow is created, which then puts a multiple client request task within the WMF fulfillment queue. And some of you have likely already gotten some of these items before. So you click on your get item, and what's really great is, while the online tool only allows a client to set up an individual subscriber RESP, we need to touch base with that client regardless, right? Because this tool isn't automated. It doesn't open the account automatically for them, nor does it generate grant forms. And so you do need to contact that client to start gathering information to create grant forms for them and to send that to them for their signature. So while you do that, it's important to have a conversation with them. And in this QRC, it indicates that you want to confirm what is their marital status. Are they married? Are they common law, or are they separated? And this is something actually that Linda didn't refer to, and maybe, Linda, you can confirm, but while they're not married, maybe they can name the father or mother of their children on the plan who might be separated from them, but if they have a good relationship, they might want to continue to own that account jointly while they don't live together anymore. And I also had clients who were like that, and I had to send individual statements to them at different addresses, which I did, but you can have parents who are no longer married as joint subscribers as well. So Linda, I don't know if you have comments on that. And if you're sharing, you might be muted.
Yes, no, and that does make total sense. That, if you're a husband and a wife and you want to have an RESP together, it makes sense to keep that person as the joint subscriber.
Yeah, and I do see in the questions here, Lucinda was asking that, and in fact, Jackie seems to have an article that shares that yes, divorced parents can be joint owners on an RESP. In fact, anyone can be a joint owner on an account, right? There's nothing preventing you on that, right? I don't mean on an RESP account, but
okay, yeah.
If you choose, and that's absolutely RESPs, you can have divorced parents as subscribers. So, confirm what their marital status is and talk to them about, what does it mean to your estate and your beneficiaries of your RESP if it's an individual subscriber or a joint subscriber, and then confirm with them what do they prefer. And so this QRC then says, okay, they confirm they want to remain an individual subscriber, and perhaps that's the only option they have, or while they could potentially have a joint subscriber, they still continue to choose to be an individual subscriber with the full knowledge of what you've shared with them. So this QRC then shares the steps that you would take for an individual subscriber account or a joint subscriber account. And the key thing here is on the individual subscriber, you basically continue with the existing workflow, but it shares, which forms you will then need to generate and create to send to the client. So, the grant forms, the ACES forms, and a client ID form if they're new to ATDIS. And it shares how you would send that to them. The big thing for compliance is, you always do create a call log, and this is very definitely an advice log, where you would document, like if they chose to continue as an individual subscriber on this document, there's a tip. It says, do make it clear in your notes that they were explained the difference, they understood the difference, and they instructed you to remain as an individual subscriber. And that way we've got it noted that it was their choice, they were aware. Okay. If it's a joint subscriber, they say, ooh, thank you, good idea, yes, I'd like my husband or my ex-husband or my common law spouse to be a joint subscriber. Then what you need to do is modify the workflow to your personal IA code and add the joint subscriber. So at this point, the account's not yet open, so it gives you an opportunity to add the joint subscriber to create a joint account. And you'd capture the data, and then a key piece is you need to modify the signatories to either or to sign. And the reason for that is, let them know that if they want to continue to manage that account online and it's a joint account, it must be an either or to sign, or else we will not be able to provide them online access to that account. Okay? So again, you regenerate those account opening documents, and what's different this time is you actually have to send them the applications, because now there's a joint subscriber and we don't have that online ability anymore, so both of them will need to sign the RESP application as well as the grant forms, the ACES forms, and potentially a client ID form. So, your options are to send that to them. You can ask the preference if they prefer to pick it up at branch or send it to them in the mail, and they can return those in a self-addressed stamped envelope if a client ID is not required. Okay? And again, keep your call log. And always in your call log, put yourself as a reminder that, you're waiting for documentation. So you've got that ability to follow up with what's outstanding. So that's the processing side. So do make sure to read this QRC. And again, this QRC was created, by me and by Jeff Price at a time where we really hadn't seen this activity happening yet. So if you have any suggestions for improvement for the QRC, absolutely, I would love to hear it. You're welcome to share your feedback. So that's the kind of the QRC on what to do now if you have a conversation with a client and it's decided it should be a joint subscriber. So I am going to stop sharing my desktop and open it up to questions if anyone has questions about the processing side. And I'm realizing now, Jackie, you had a question on processing. Maybe it would have been processing an estate and not necessarily processing for a joint account. But so please, if any of you have questions.
Actually, Michelle, my question was around processing in our system. So I'm wondering if there will be any kind of workaround for RESP accounts that already exist that only have one subscriber. So obviously through the WMF process have been set up with just one subscriber because you cannot go in and do a camp to change that to joint. So what we would be looking at having to do then is set up an entirely new RESP account, grant forms, plus we would also have to do the transfer form. So I'm wondering if there's any possibility of having a workaround for that.
Yeah, and you're referring to this was prior online advice, right? So it's not necessarily a new problem created by online advice.
Yeah. Not necessarily. I've had an RESP that I opened since we've been live. It was opened as a single account because we didn't have this state information. So now at this point, I'm going to have to go back to that client and say, oh, hey, by the way, it should be joined. Here, I need to send you all new documents again.
Yeah. Linda and I chatted about this, and I know we had a bit of going back and forth with the RESP operations team. I don't know if that's what we want to call them. I know Linda was kind of looking into that as what we could go forward. Linda, do you have any comments or updates, or it's certainly a takeaway?
All Donna said was that it would be a brand new account.
Yeah. Yeah. So, Jackie, at this stage of the game, you're right. That is the process. We have alerted the team that that's not an ideal process. Linda has actually found resources to show that other financial institutions have much simpler processes to add a joint subscriber. And that information has been shared with our operations team. So, maybe, you can alert me whether or not this is like a high priority, a real issue that we need to try to see if we can escalate and I can't tell the operations team what their priorities need to be, but we could tell them that it would be something that would really be great for our team. So, so Trevor so you had a single subscriber, Trevor, and then you went and opened a joint one and transferred it? Yeah. I know it's not ideal, but we're aware that that's the case, and we've had conversations with operations. So, yeah. So the ideal is, and I'm hoping now that this meeting has alerted us all. So the QRC was there prior to launch, but I know that we were all, it's like drinking from a fire hose, right? So many QRCs being put up, so many new processes, new technology, that there was no way we could expect for all of you to do everything 100%. So I was really hoping that this live meeting could create that awareness for you so that you can turn it into a joint subscriber account before it's open, which would be really the best way to go. So that conversation with the customer is important. Yeah, I recognize that, Jackie.
Can I ask a question from Linda about RESPs, but not about the estate planning part of it?
Sure. Honey.
Linda, if the child doesn't go to school and we have only one parent as a subscriber, up to the limit for the interest can be transferred to that subscriber RRSP if she or he has the contributions room left, right?
Well, basically, yeah, the income, it would only be the income that
Income earned, right.
Yeah.
So when we are saying that, you know, there is no difference if you open the RESP account as an individual subscriber or joint subscriber, this matter would be the only thing that makes difference in case that subscriber doesn't have any contributions room left in her or his RRSP. Am I right?
Yeah, you're exactly right. And quite often, someone will have had an RESP for 15 years as an individual subscriber, and they don't add their spouse until as a joint subscriber until further down the road to be able to contribute that money to an RSP.
Oh, so it can be done.
You can add a joint spouse subscriber, or I guess not add in our case, but transfer it to a joint account at any time. So
just a question. So as long as I know, you cannot join a new subscriber to an existing account. So do you mean opening a joint RESP and transfer this one over?
Yes.
So other institutions have a simpler process where it's a letter of direction and a form, and they're just adding it on, and the account number doesn't change, and we don't have that ability. So I don't know if it's, I'm not sure why that is exactly.
Yeah.
So there are some institutions that have the ability to do it, but it very well be a system limitation.
Okay, so this is the only limitation we should know in offering an individual subscriber RESP, right?
Well, it's not the only limitation. There's the estate concerns, right? But yeah.
Okay, thank you.
Yeah.
Yeah, the estate and being subject to probate fees and things like that. But yes, the bottom line, we say the best to have a joint. Yeah, if it's for your own kids, definitely. That it makes sense to have your husband as the joint subscriber.
Yep, exactly. So I think best practice, as Christy says, family plan, even though they have only one child, but they may have future children, even though they're not planning for it. So family plan and a joint plan is, I would say, the best approach if, you know, the scenario's in place. If it's not a single parent, if there's a couple or even a divorced couple, absolutely. I think that's what Linda is sharing is a best practice for a person to consider.
Michelle, do you think down the road this new online advice tool may let customers to open a joint RESP?
Very potentially, but I would say probably not in the next 12 months. You know, that's certainly, you know, feedback that, you know, I would love that if it could, but I think we were trying to keep the scope of the whole project as a manageable one, but absolutely something to consider for the future. Boy, there's a lot of chit-chat going on.
Linda, I have a question for you that came over to me. I have clients that are indefinitely moving to the U.S. And their kid may come back for school, they don't know, but they don't want to collapse the plan. So they're asking if they could transfer it into the wife's sister's name to carry on for the child.
No.
So that's not considered blood then.
I'll have to look into it because I get confused as to when you can transfer to change beneficiaries or change ownership. I don't think, actually, maybe you can.
Just because they say if in the event the child comes back to Canada for school, they want the RESP there, but we're not sure if the sister can actually take over a subscriber from the parents.
Okay, I'll have to look it up and get back to you.
Okay.
Okay. And I know that, for example, we had an RESP for my nephew and niece, and they went to school in the U.S. They were able to use educational assistance payments to go to U.S. schools. But it's probably the subscribers having an American address that...
And there are all beneficiaries, I think.
Sorry.
An RESP account is taxable if you are considered a U.S. person.
Yeah. Okay.
So
And isn't it also the beneficiary has to be resident of Canada to use it as an EAP?
I think to get the grant, they don't have to. They don't have to be resident when they're receiving payment.
Right.
But I think they have to be to receive the grant.
Yeah.
Right.
Yeah, because like I say, he's in Boston going to school, still a Canadian resident, but going to school in Boston, right? So was able to use the educational assistance payment for that. But yeah, in terms of subscribers, yeah, that would be great if you could take that one away, Linda.
Yeah.
All right. I have another poll. Let's see if I can figure out how to share that again. This one. So, this one is about whether or not you're confident that you understand how to proceed when you get an RESP account opening in the WMF fulfillment queue. Oh, I've got a little bit of work to do. All right, so total response is 10. So we had 14 last time, so I'm waiting for 4 more responses. There we go, we've got 12. Give the remaining 2 a few more moments, but then again, they may have been called out. 14, there we are. All right, so I'm going to close this poll. So we do have one person not feeling very confident at all, and that's okay, because this is a very new process, and a lot of this is very new. So, I'd encourage whoever that person is, if you want to give me an email or have a chat on Link, absolutely, would love to do that with you. Or, to go take a look at the resource and see if that QRC helps clarify or not. 50% of you are somewhat confident, so I'd be happy to get feedback from all of you. If you want to send me an email afterwards to share what would make you feel confident. Is it maybe, again, taking time to go look at the QRC or asking a few questions? Absolutely, let's do that, because I do want to help you feel confident. 36% of you are confident, and 1 of you is very confident. So that's really great, and I think this distribution is really normal because it's a process, and boy, we have a lot of new processes coming at us recently. So I do have one last, whoops, did I share that? I didn't. There we go. You couldn't see the poll. Here I am talking to you about it. All right, so one last poll that I wanted to share, and that is with regards to the entire call. Here we go. So this poll is just to give us some feedback. Did you find that this meeting was valuable, and would you like more meeting like this in the future to help build your knowledge to better support clients? So we have 10 respondents already. And so far it's looking like you do want more of these webinars or live meetings in the future. I've got 12 responses, so I'm looking for 2 more before I close it. 13.
One of them might be me, Linda.
Ah,
So I can vote.
okay, perfect. All right, so I'll close the poll, and now here I'm showing the results. So this is awesome. 11 out of the 14 of you are saying yes, extremely valuable, more like this, please. So we're hoping for sure to offer more of these types of meetings for you to help build your knowledge and confidence as you support clients. And the others are saying absolutely it's valuable, you would attend again. So thank you very much for that feedback. So we are down to our last 5 minutes. Any final questions for either Linda and I, or perhaps not just questions, maybe feedbacks, or what you would like to see in this whole process?
Actually, I have a question. So if a customer is already in the branch and they prefer to have a joint subscriber RESP account, or if they don't say anything, but they are both in the branch, knowing that we need them to, they need our help for the grant forms, do you think it is better to just do it through the WMF and not send them home to go through the online advice tool? What would you do?
Yeah, actually, I don't think Andrew is in this call, but Andrew did have a scenario. Mind you, it was an individual person, but a PB brought in Andrew to support on an RESP account opening. So what they did is, I think it's always important to create a plan. So you support the clients, over video with the PB, create their plan for them, and then it will create that WMF workflow. And then after that, just go into the workflow and modify it. Just go in and modify it to your IA code and then start gathering the joint account information. I think that's the way I would suggest, but maybe some of you have some thoughts or have already done this already with a PB that you'd like to share. But absolutely, I think at least it gives them that opportunity to have their plan online, and to understand that, if they select either or to sign, that they could continue and monitor their progress and, make requests to increase packs, etc., which if you didn't do it through the online experience, they would not be able to do going forward, right?
Okay.
Michelle, what would happen in the case where we had a husband and wife? They each went through ATB online advice and they each requested an RESP. Can we then somehow combine those two workflows?
Yeah, I think what you would do, and I'm not a WMF expert, but tell me if this makes sense. You would, hopefully someone would see that these are spouses and they've both sent account opening requests. You would contact that client, confirm that they are indeed spouses and that they want a joint account. You'd abandon one workflow and you would convert the other workflow into a joint account. Does that make sense?
Yeah.
That's what logic is telling me, but I don't work in WMF. So
I'm wondering because then a lot of the KYC information for each, like for the husband and the wife, would already be populated within the site, right? So we would have a lot of that information already.
Yeah. Yeah. So, a lot of this, I don't know if I hate to say, or it is what it is. It's a bit of a learn as we go, right? And I suppose it's very possible if a husband and wife on a, Thursday night sat down at 8 o'clock and started doing their planning, they might have each created their profile and each requested an RESP account. You would almost hope that if they were doing together, they'd realize they'd only want one account, but very potentially, and that's how I would suggest. You're going to have a conversation with them, confirm they want to joint, abandon one, modify the other. Any other questions before we close out? All right. Well, I want to say thank you so much to Linda. I know, Linda, you put a lot of work into creating those slides for us and the wonderful, wonderful examples. The richness of those examples really make it more real for all of us. So thank you for that. And thank you to all of you, the advisors who signed into this and asked your questions and provided such great feedback through the little surveys or polls that we had. So any feedback that you want to send, please do send me an email. And if you have any requests for this type of meeting on another subject, absolutely send that to me as well. So, seg funds. Oh, and thank you, Lucinda. Very nice. Let me see that I've captured everything here before I close out. So, perfect. Just a bunch of nice notes, and Shane, I'll certainly set that aside as well as a learning piece. So thank you, everyone, and have a great afternoon.
And thanks for having me, Michelle.
Yes, thank you, Linda.